Hi, everybody.
Hello.
Hi.
I'm gonna give everybody a few minutes to get on the webinar. They should be joining or not. um, so I just wanted to welcome everybody to our webinar on New York surrogacy. I'm really excited about this. It's something that's been in the works for many years, and I'm really, really happy to have two great people on with us today. So we have Richard Vaughn from the International Fertility Law Group. Rich Vaughn combines his passion for family formation with over 20 years of experience in business and technology law when he founded the International Fertility Law Group, one of the most successful and best-known law firms in the world, focusing on assisted reproductive technology law. Rich Vaughn is a graduate of Loyola University Chicago School of Law and is the past chair of the American Bar Association Family Law Section Committee on Assisted Reproductive Technology. Rich is a proud advocate for LGBTQ equality and gay and lesbian parenting as a member and supporter of family equality and men having babies. Rich and his spouse, Tommy, are the proud parents through egg donation and surrogacy of twin sons, Aiden and Austin. Since launching IFLG, he has had the opportunity to help thousands of intended parents from all over the world create families via assisted reproduction. And I should add in and hundreds, possibly thousands of donor concierge parents as well. So welcome, Rich.
Thank you. Thank you. Good to be here.
And we also have Marnie Dennenberg, who's the Donor Concierge's Director of Private Client Services. Marnie has extensive background in family building, having worked previously as client relations manager at a gestational surrogacy agency and as program director of newborn domestic adoptions at a private nonprofit adoption agency. As an adult adoptee herself, Marnie brings a deep understanding of the complex and sensitive nature of this work. Marnie is formally trained as an attorney with experience working as a senior court attorney on civil and criminal appeals at the New York State Appellate Division, Second Department. She holds a Bachelor of Art degree from the University of Michigan and a Juris Doctorate from Brooklyn Law School. So thanks, Marnie, for joining us. You work with a lot of our clients from New York and international clients, and so I thought it'd be interesting to have your view on how the law could affect our donor concierge clients. So I just wanted to hand over to Rich, who's going to give us an overview of the CPSA New York surrogacy law now.
Thanks, Michelle. So a little bit more about my background as a founder of International Fertility Law Group. We are a national law firm. We have offices in New York. We have offices in Dallas, Los Angeles, and Beijing. We have of-counsel attorneys that work with us in every state. So we have a reason to be involved in and to understand the law in every state. So I'm very happy to be here to help explain the new New York law, the Child Parent Security Act. Now, I also, as you mentioned, chaired the American Bar Association Assisted Reproduction Committee for a number of years. During my tenure, we passed at the ABA, which is the largest and most bureaucratic group of lawyers in the world, model legislation governing assisted reproduction and specifically surrogacy, and model legislation specifically governing assisted reproduction agencies. So it's with that background in mind that I've also been involved in helping support the advocacy effort in New York and working with the New York Department of Health on its regulations that they're trying to promulgate to have a licensing structure rather for agencies in New York, which is a new feature of the bill. So we'll talk about that in a little bit. Overall, the Child Parent Security Act, or CPSA, as I might say a few times, it's long-awaited reform, and it's effective as of Monday, just in a few days from now, Monday, February 15th. It removes a significant number of obstacles to surrogacy, and it protects the rights of intended parents to create families through assisted reproduction, and it helps remove the stigma and the insecurity that were faced by non-traditional families as well. But in order to benefit from it, from these broad reforms, intended parents really must follow the rules enacted by the law. These rules were put in place to both foster reproductive rights, but also to protect all parties against potential harm. So it's really important that anyone engaging in assisted reproduction in New York be aware of this law or consult with an attorney who is familiar with this law. Now, the main focus today is how the CPSA addresses surrogacy, the requirements for surrogates, and intended parents and agencies, which are now referred to in the law as matching programs or surrogacy programs, as well as some of the requirements that are in place for surrogacy agreements between intended parents and surrogates, and how parentage is established through a surrogacy arrangement. If we have time, we'll also spend time talking about a couple of other aspects of the bill, which I'll get into later. But one of the two unique features of the law in New York, as compared to surrogacy law in the rest of the country, is that the New York law establishes a surrogate's Bill of Rights, and it establishes requirements for surrogacy matching programs that they must abide by. And it requires that these matching programs also be licensed if they're doing business in New York. And these are extremely beneficial for intended parents and surrogates, and also quite unique around the country. So before I get into that, I would like to just pay a little homage to the history of how we got here. Many of you may remember the Mary Beth Whitehead case, the Baby M case from the 80s. This was a case where a surrogate who was what we called then a traditional surrogate, she provided her egg and carried. She entered into this arrangement with intended parents, and then when the baby was born, she changed her mind and wanted to keep the child. That involved a lot of litigation after that. She was still declared the mother, and the parents ended up with custody of the child. But as a result of that debacle, many states made surrogacy illegal and put a lot of restrictions on surrogacy, including New York, DC, and Michigan, just to name a few. So for many years, of course, in New York, compensated surrogacy was not allowed. In fact, it was illegal. Altruistic surrogacy, on the other hand, was allowed. Now, altruistic surrogacy is where a surrogate is not receiving any money for her efforts in the process. It's okay to reimburse expenses in an altruistic surrogacy, but otherwise she cannot be paid for her time and effort. And so for many New Yorkers, there weren't that many surrogates available, and building a family through surrogacy meant they had to go outside the state to engage in surrogacy. And agencies and attorneys, and for the most part clinics, also could not be involved in any compensated surrogacy arrangements in New York. Now, the impetus behind changing this law actually started with a colleague and a friend of mine, Denise Seidelman, who had an intended father who was engaged in an altruistic surrogacy in New York. And because there was no law really defining how parentage would be established, the court made him adopt his own child. She thought that was ludicrous. It is ludicrous. And that started her down this path of drafting a bill that started out as a surrogacy bill, but over the 11 or 12 years since then, grew into a massive parentage bill addressing more than just surrogacy. Eventually, as she built the grassroots effort and the grassroots campaign, the governor took interest and appointed a task force on life and the law, the Department of Health in New York, to look into surrogacy. And they issued a report in December of 2017, which basically supported the idea that compensated surrogacy should be allowed. This gained momentum, and eventually the law was passed in April of 2020, just last year, right at the cliffhanger of COVID. So it's amazing that it passed during this crazy last year that we've all been through. For many, this seemed like a pipe dream, especially for all those who worked so hard year after year with rejection, after punishing year of rejection again and again and again. But the once impossible dream came true. And as a side note, I'm mentioning dream because I actually woke up from a dream this morning about this webinar. I was thinking about it, and in my dream, which woke me up, rightfully so, I was singing my conclusion to the webinar. I will spare you all from that nightmare. Or that would be cruel and unusual punishment. But back to the dream of legalizing surrogacy in New York. Again, I mentioned this is a law that started out as a surrogacy bill, and it covers a wide variety of other topics, including sperm donation, egg donation, embryo donation. It covers posthumous conception, and it covers embryo disposition agreements. So sometimes couples have lots of leftover embryos, and maybe one of them wants to use them after a divorce. And it allows the parties to engage in an embryo disposition agreement. There's some requirements behind that as well, which is really interesting because we have this growing problem of all these stored embryos, and somebody still wants to use them, but they can't because there's no mechanism to free the other progenitor from any parental responsibilities. And the New York law does this. It's the first law that I'm aware of that does it. So it covers that, and it covers some other long needed updates regarding the establishment of parentage in assisted reproduction generally, as well as surrogacy, surrogacy agreements, and parentage in surrogacy matters. Now, one other final point, I will get to the bill, to the law. As you can imagine, after years and years of modifications and compromising to get a bill passed into law and addressing all the concerns and the special interest groups, patching this together, as it were, there's often a need for cleanup and for some fine tuning. Ideally, most of this is done before the bill is passed, but that doesn't always happen. And sometimes you end up with mistakes in the bill or things that were unintended. The bigger the bill, having been involved in lots of legislation myself, the bigger the bill, the more likely it is that something will be messed up and something needs to be corrected. We often say that creating legislation is like creating sausage. It's not pretty. So there is underway a number of efforts to have a cleanup bill proposed. It is not passed yet. I don't even know if it's been introduced yet, but it's underway, and there'll be a lot of things that we discussed today that might be changed soon by a cleanup bill. But because it hasn't been proposed, it hasn't been voted on yet, there's not much we can really say about it at the moment. I just wanted to address that one white elephant in the room. So with that, long introduction, sorry about that. The main focus of today is to talk about gestational surrogacy arrangements in New York. So I'd like to start with the prerequisites for parents and surrogates, then we'll go into what the requirements are for surrogacy contracts, agencies, and how parentage is established. Now, the biggest advancement, as we've mentioned already, is that compensated surrogacy is no longer prohibited in the state of New York. It is now legal in New York for a person acting as a surrogate, and that's the language used in the law, to be compensated for the extraordinary and the beautiful gift of her time and her effort in going through everything she goes through to help these intended parents have a baby, going through medical screening, going through psychological screening, criminal background checks, psychological counseling, and of course, carrying a baby and, God willing, delivering a baby for these intended parents. So it's now legal to pay her for all of that time and effort, as it should be. Now, the compensation is allowed up to 8 weeks post-birth. The surrogacy agreements are specifically valid as long as they comply with the law. So there's no question about the enforceability of these contracts. And pre-birth parentage orders are allowed. So parents can go to court, and if their contract complies with the law, get a court order that says at birth they are the parents, and they can get that court order prior to the birth. Now, who qualifies? What are the requirements for a gestational carrier? A gestational carrier must be at least age 21. She must be a US citizen or a lawful permanent resident. And if at least one of the intended parents hasn't been a resident of New York for 6 months, she must have been a resident of New York for at least 6 months. Now, this is one of the issues being addressed in the cleanup bill. It wasn't intended to be that restrictive regarding intended parents being resident of New York. The main issue really is if the surrogate is in New York, but this is one of the issues covered in the cleanup bill. The carrier, as a gestational carrier, also must not provide any of the gametes involved in the embryo production. So she cannot provide the egg, which would be the case in most situations, but knowing that we have medical advancements in technology, she cannot also provide sperm. So the statute speaks very generically, gender neutrally, to any gametes. She cannot provide any gametes. She must go through medical evaluation, of course. This isn't anything new. This is a basic requirement of most surrogacy statutes around the country and best practices, even in states where they don't have surrogacy statutes, but it's now spelled out in this law. And she must, of course, give informed consent to the doctor after discussing the risks of going through surrogacy with her doctor. So that informed consent must be given before she proceeds. Intended parents, what's the requirement for an intended parent under the law? At least one intended parent must be a citizen or lawful permanent resident of the US, and this is the part that might be fixed in the cleanup bill, and also a resident of New York for 6 months. So we're working on that. Now, intended parents can be single, they can be married, they can be partnered, doesn't really matter. So if you are an intended parent, single or coupled in any way, you are allowed to proceed under the law in New York. One interesting feature that is nice to see for the protection of the child is that intended parents must have wills in place prior to the embryo transfer. The main reason for this isn't because we care about your property, it's because we care about the child and that a guardian has been appointed in the event that the intended parent dies before the birth. And that's something that we've always insisted on in our practice, and many other states around the country have that just as a best practice, if not codified in the law. Okay. Now, those are the basic requirements for gestational carriers and for parents, but there's more in terms of what must be provided to the carrier that I want to get into. And this is also part of what would be required in the contract itself. Now, the carrier must be provided with health insurance to cover her during the pregnancy and for 12 months post-birth or any other termination of the pregnancy. So if a pregnancy ends in a miscarriage, she still must have the insurance in place for 12 months post that event. Now, the health insurance must be in place prior to her taking any medication or commencing any treatment to further the embryo transfer. And there's some issues that are wrapped up in a cleanup bill around this timing of when, in fact, the insurance must be put in place. And this insurance must cover preconception care and behavioral health care. This is another one of the issues in the cleanup bill because behavioral health care was never really defined in the bill. I think what was intended was the mental health counseling that she'd be provided with, but it wasn't defined. So the cleanup bill is trying to define that. Now, the health insurance must be paid for by the intended parents, unless there is an exception. If it's an altruistic surrogacy where she's not being paid, she can waive the right to have the parents required to pay for her insurance. And this is an effort to help, eliminate some of the barriers to surrogacy because it is expensive. So if it's an altruistic surrogacy, it's often with friends or family, and people are trying to cut costs if possible. So that's been allowed as an exception to the parents having to pay for the health insurance, only if it's altruistic. Now, the surrogate must also be provided with life insurance, and the law specifically outlines that she must be provided with $750,000 of short-term life insurance to cover her during the pregnancy. God forbid she were to die during this process. So the coverage amount is $750,000 or less if she somehow doesn't qualify for that amount. And it has to take effect, just like with the health insurance, prior to taking medication and be in place for 12 months post-birth or any other termination of the pregnancy. Carriers must also be provided with disability insurance if they request it, and counseling if she requests it, and the surrogate's bill of rights. Now, this is an important feature we'll talk about with agencies as well, but it's important that she has acknowledged that she's received the surrogate's bill of rights, which is outlined in the CPSA. Now, a lot of the stuff we've talked about or will talk about will be encompassed in the bill of rights, so I'll save that for a little bit later. Now, the law does require that all parties, so not just the surrogate, but all parties must have independent legal counsel of their own choosing. And a unique feature of the New York law is that the attorneys must be engaged throughout the arrangement. This is a little different than what you might see in other states around the country. This can vary, of course, from law firm and attorney to attorney, but the requirement is that in New York, the attorney is engaged throughout the process, whereas in other states, you might see an attorney engaged just for the contract and then they disengage, and then they re-engage when it's time for the court process. So the New York law requires that they be engaged throughout, and that's to make sure the parties have counsel throughout the process. Now, the law also states that, of course, that there must be an escrow account. And this is a place where funds are held so that all of the gestational carrier's fees and expenses and health insurance expenses and whatnot can be paid through the escrow account. And that escrow account must be funded with at least her base compensation and the reasonable anticipated expenses prior to any medical procedure other than her medical evaluations to be approved as a surrogate. So before she starts injections or an embryo transfer, that escrow account must be funded. And that account cannot be held or managed by an attorney for one of the parties. So the New York law has made it very clear that they want completely independent relations where the escrow account is held so that there's no bias or conflict of interest with regard to whoever's holding the escrow account. And an attorney for a party can't hold escrow, but an attorney-owned and managed agency can hold escrow the way that the law is currently written. And there are going to be some small tweaks here in the cleanup bill as well. Now, some sort of nitpicky details about the contracts, that they must be executed by all parties in front of 2 witnesses prior to the GC starting her medication or medical procedures. It must disclose how the parents are going to pay for the surrogate's medical expenses. It must disclose how the parents are going to pay for the child's medical expenses once the child is born. It has to include the sort of the source of the genetics. It has to address whether there was donor material involved or the intended parents material, and it must state the name and contact information for a surrogacy program if one was involved. Now, the contract also, and this isn't unique for New York or any other state, but it must state that the surrogate agrees to surrender custody of the child immediately upon birth, and that the parents agree to accept custody of any resulting child immediately upon birth, regardless of the number of children, the gender, their mental or physical condition, regardless of any defects, or even if, heaven forbid, the lab made an error and transferred the wrong embryo. It is their responsibility, not the surrogates. And that's fairly common in other states as well, but it's nice to see it clearly written in this bill. The contract must, as I mentioned, indicate that the surrogate has acknowledged she's received a copy of the surrogate's Bill of Rights from their attorney. The contract must indicate that the parents have executed a will prior to embryo transfer or have it in place, or guardianship documents. And there's another feature here that this relates to the Bill of Rights. It must make it clear that the surrogate, and this is really important, has the right to make all health and welfare decisions concerning her health and the pregnancy. It's very important, that she has those rights, and it's somewhat consistent with what we see in other states as well, but it's very specifically addressed in this statute and addressed in the Bill of Rights as well. Let's see if I think I hit everything else here. Yeah. All right. Now, the statute also makes it clear that the surrogacy agreement could be terminated. Any party can terminate this agreement prior to the gestational carer becoming pregnant upon giving written notice. So that's spelled out in the contract as well. Now, that's it for the contract and the requirements for intended parents and surrogates. Let's talk briefly about parentage. The whole point of this is that intended parents can become the legal parents of the resulting child. So how does New York address this? As I mentioned earlier, attorneys must certify that the contract complies with the New York statute, and those attorneys must be licensed in New York. If all of the requirements of the statute have been met as certified by the attorneys, here's the nice thing: the court shall enter the order declaring the intended parents as the legal parents of the child. There's really no discretion here. And it is allowed to be declared in a pre-birth order, so the parties can petition the court during the pregnancy and have the court sign a pre-birth order, and that order will become effective at birth. It doesn't make the intended parents the legal parents during the pregnancy. It becomes effective at birth. Now, if for some reason the surrogacy agreement does not comply with the statute, the court can still enter an order of parentage, but it is not bound by the requirements of the CPSA that the court shall enter the order. The court will consider all other factors, especially those affecting the child's best interests and other parentage provisions in the New York law. Okay, I think that's all I wanted to say on that. And let's talk about what's new as compared to other surrogacy bills around the country. We've already mentioned it a couple of times. The Bill of Rights, except as otherwise provided by law, any written or verbal agreement purporting to waive or limit any of these rights is deemed to be void and against public policy. That's a very strong statement in the Bill of Rights. So these rights are enumerated and they are not exclusive, and they are in addition to any other rights provided by law any other regulation or anything that the surrogacy agreement might be addressing. So again, the Bill of Rights includes that the surrogate must be allowed to make all health and welfare decisions regarding herself and the pregnancy. She's entitled to separate independent legal counsel. Her health insurance and medical costs will be covered by the intended parents for a period of time, as we mentioned, up to 12 months post-birth or other termination of the pregnancy. She's entitled to counseling if she needs it or wants it. She's entitled to life insurance, as we've discussed. And the Bill of Rights indicates that the surrogate has the right to terminate the agreement prior to becoming pregnant. So it's very clear. It's not terribly long, but it's a list of very important rights that the New York legislature wanted to make sure were in place to protect the surrogate.
Rich, just to jump in there, are there any other states that have anything like this? Or is this a completely new requirement?
The Bill of Rights itself, this structure of a Bill of Rights, that is new. No other state has a Bill of Rights. Some of the enumerated rights are already included in other statutes. So there are some statutes that indicate that the surrogate is allowed to make health and welfare decisions for herself. Some statutes require independent legal counsel. And so these are not new. They're just, none of them have ever been put together in a Bill of Rights. So it's a statement, that's important. And that's really a unique feature of the New York law. All right, the other unique thing that I'm excited about, having worked on model legislation at the American Bar Association to govern assisted reproduction agencies, is that an agency surrogacy matching program is now subject to certain requirements, including the requirement to be licensed once the New York Department of Health promulgates its licensing requirements. They're working on it. I've talked to them several times because they know I was involved in writing that model legislation. Excuse me for 1 second. So one of the things that the surrogacy matching programs must do is, well, let's start off with what's defined. What is the surrogacy program? How is a surrogacy program defined? So it's broadly defined to include any agency, agent, business, or individual engaged in arranging or facilitating transactions contemplated by a surrogacy agreement. So it's a very broad definition, and it applies to any of those operating in New York, and it says that they must be licensed by the state. Now, fertility clinics and gamete banks also doing business in New York, referred to as assisted reproduction service providers, are also subject to the regulations, and those will be promulgated by the Department of Health, as I mentioned. Now, the agencies must be licensed if they're doing business in New York, if they're involved in a match where a gestational carrier is a New York resident, or if they're involved in a match where the clinic is in New York. Now, this is kind of overly broad, and it's another area where the cleanup bill is looking to tie up some loose ends and make it clear that just because a surrogate did a transfer in a clinic in New York doesn't mean that the agency has to be licensed. If she lives in Florida or Texas or California or Oregon, but the clinic was in New York, it does not mean that that agency must be licensed in New York. I think that was the original intent. We'll see how it all turns out when the cleanup bill gets voted on. Now, the surrogacy program, whether owned or managed in whole or part by an attorney, cannot also be an attorney representing one of the parties. Okay, so if it's an attorney-owned agency, the parties have to have a separate attorney, not affiliated with the agency. The program also cannot be the healthcare provider. So basically the same thing. So you can't be an attorney, you can't be an agency and also be the attorney for the party or the medical program for the parties. The program also cannot pay for or receive money from an attorney or a doctor. So basically we're trying to make sure there are no referral fees, no conflicts of interest in that relationship. The surrogacy program must also provide all parties, and I've mentioned this before, at the time of the initial consultation, the surrogate's Bill of Rights. So all parties must be advised of this at the very first consultation. And the surrogacy program must keep all funds paid by or on behalf of intended parents in an escrow account that is separate from the agency's operating account. Okay. Any questions about that?
There is a question. Do you think this legislation will make surrogacy in New York the most expensive in the US?
I do. Super easy question to answer. You know, it's interesting because politically, when there were a lot of people stepping up against surrogacy when the bill was being proposed, one of the complaints, the criticisms was that this was only for wealthy people, and we wanted to create the ability for people to access surrogacy at not such an expensive rate, but you know, providing insurance, health insurance, for instance, for 12 months post-birth, that's going to add a significant expense. There may be ways to mitigate that expense, but it does add a significant expense. I don't think increasing life insurance to $750,000 is going to break anybody's bank. It might, you know, add another $200, $300, $400 in the premium, but that alone isn't really going to have a huge impact. But it's a good thing, because what we see in a lot of these standard contracts around the rest of the country where we also practice is that the life insurance provision is only for $250,000. And if you think about what that covers these days, it doesn't cover that much. So I'm really happy to see that amount increase.
Thank you. And just taking that a step further, maybe we should talk a little bit about surrogate compensation, gestational surrogate compensation.
Yeah, the standard in the law is that basically there's no predefined amount. It just must be reasonable and negotiated in good faith. And so with both parties having independent, separate legal representation, you know, they can negotiate that amount in good faith. You know, as what happens in real practice is most agencies have a program that the parties agree to follow, and sometimes the base compensation, the pregnancy compensation, is sort of set and defined by program, but the parties will have their own independent counsel to negotiate and finalize what they all feel comfortable with.
One thing I like about this is the transparency that they're trying to offer with regard to independent responsibilities, keeping things separate, enforceability that will give families great peace of mind moving forward with a surrogacy arrangement in New York, and essentially, like, even the declaration of parentage, the fact that you said there's no wiggle room, that there's a process, pre-birth order, and effective at the time of birth, it makes sense why they do that. But it just seems like there's a lot of transparency here, so people will feel more comfortable moving forward, even though there's things that need to be cleaned up.
Completely agree. Yeah, I mean, look, it's not a bad thing that there are still things that need to be cleaned up and fine-tuned. That's just the nature of legislation sometimes. So we could argue with, you know, the process, but at least we now have a law in New York that makes compensated surrogacy legal, and you know, we're going to work on fine-tuning those things. And some of this will come through the cleanup bill, and some of it will come over time with custom and practice, as all the attorneys and the judges get more familiar with and comfortable with how these things actually work in practice.
There's a couple questions, Rich. When can we expect the cleanup bill to be passed?
The original intention was to have the cleanup bill proposed in January or February. I don't think it's been put forth yet completely. I think there may even be a couple of different cleanup bills that are being looked at. So soon, but I don't have any updates on the exact timing. I mean, I checked again this morning and there were no updates.
And another question related to that is that since the state has not set forth the licensing structure, should agencies wait on recruiting New York GCs until after they've completed the licensing once it's available?
No, I think what's really clear in the way the law has been written is that the agencies may operate and be involved in New York compensated surrogacy arrangements as of February 15th. But once the licensing regulations come out, they're going to need to apply right away and you know, take care of that quickly.
One thing that we should also discuss briefly is who can take advantage of New York surrogacy arrangements. It seems that international families will not be able to do this.
That's correct. Yeah, only intended parents that are U.S. citizens or lawful permanent residents are allowed to engage in surrogacy with a surrogate in New York. So that does technically mean that a U.S. citizen living abroad would qualify, but it will significantly reduce the amount of international intended parents able to engage in surrogacy in New York.
Mm-hmm.
How does it affect clinics? So clinics who previously were not able to do transfers to a surrogate, whether their surrogate was in New York or from outside the state? Does this give them more flexibility?
Absolutely. Yeah, the prior law that was repealed by the CPSA made it illegal to be involved in any kind of compensated surrogacy, even if, and many clinics took the position that even if the surrogate was in a different state, they didn't want to be involved in the embryo transfer, even if that's the only connection. She came for the screening and came for the transfer, or maybe even just one of those. They didn't want to touch it. Now I think they have the room to breathe, and they can relax and know that they're not committing a crime or potentially committing a crime if a surrogate from another part of the country comes there for a transfer. So now clinics are able to continue servicing their intended parents who are New York residents, and those New York residents do not now need to go to some other clinic in another state to finish what they were starting.
But would this clinic have to have the surrogate's bill of rights and go through all that process, even if she's coming from out of state?
I think that's probably a good idea. I don't know that it's required, but I would err on the side of caution. There's nothing wrong with giving the surrogate's bill of rights to a surrogate. I think a lot of the things that are mentioned in the Bill of Rights are, again, carried forward in best practices in many other states and in some of the statutes in other states, not quite so specifically as the Bill of Rights itself, but as I mentioned, a lot of that's actually in practice in other places.
How do you think that this is going to impact, not just, because you did mention briefly that this is going to impact egg donor arrangements, sperm donation, embryo donation. How do you think this is going to impact this, and especially in terms of matching agencies and their roles?
Well, it doesn't do much else with regard to egg donor agencies. Egg donor agencies must be licensed under the tissue bank regulations in New York, so that hasn't changed. What the CPSA did was clarify that it is okay to pay an egg donor, and that it's clear under the new CPSA that a donor of any kind is not a parent of a child conceived by assisted reproduction where there is proof of donative intent, of their intent to donate and not be a parent. So there will need to be clear and convincing evidence and a written record to indicate that. But as long as their donative intent is written in a record that's clear and convincing, then they are not a parent of any kind. So that's nice. That's very clear.
Mm-hmm.
Getting back, there's another question. Can international patients do surrogacy transfers in New York State if the surrogate is from out of state?
Yes.
That's a good thing for New York clinics.
The clinics, yeah.
Absolutely.
Especially for lots of intended parents who don't have access to the kind of clinic that they would like to complete these procedures in Europe. New York is a lot closer than other parts of the country.
Yes, it is.
But wasn't the intention of the bill to make sure that New York didn't become a destination for surrogacy? So how does this? There seems a little few gray areas.
Well, it still has a limiting effect because then those surrogacy arrangements can't actually take place in New York. Okay, but it does allow the clinics to be involved in the medical procedures.
So in thinking about an intended parent, like one of our clients who come to us, what should they look for if they haven't come to us, but they're looking to do surrogacy, their clinics in New York? How do they know if the agency's licensed? It seems confusing for them still through all of this. What's the first thing they should be looking? When you say licensed, is this like a Better Business Bureau license? I know it's Department of Health, but is it a tissue license? How is it going to be implemented?
Well, that's what we're looking for direction on from the New York Department of Health as to what they're going to require. But what I can tell you from the Model Act that the ABA endorsed governing assisted reproduction agencies is that it requires certain things regarding record keeping and clarity in their retainer agreements, and that they comply with privacy laws, and that they have informed consent for proceeding. So those are the kinds of things we're looking for from the Department of Health. What I would say, just as a simple first starting place, is to talk to an attorney or law firm licensed in New York, so you can get kind of an understanding of New York law. But at the very beginning of an intended parent's journey, they often don't know where they might end up finding a surrogate. They're, of course, if they're starting out with an agency, the agency may have surrogates in different parts of the country. So if they get to a place where they think they might be engaging in a New York surrogacy arrangement with a New York gestational carrier, then they should contact an unintended parent, a law firm licensed in New York.
And actually, Marnie, this is a question that maybe you can answer. It says, are matching agencies already screening and approving New York carriers despite the cleanup bill not being ready? And I know you talk to a lot of agencies. Have you heard of anybody doing that yet?
I have not. And I remember when the laws changed in New Jersey, it was a slow start. People are slow to move into these processes because they want to do so. Nobody wants something to go wrong. So slow moving and we'll see how it goes. Yeah.
One last question, and unless you got more to talk about, Rich, I know we kind of, there's been an overview, but this is a good question. Is there anything in the law that would restrict the gestational carrier and the intended parent should they agree on a termination clause?
So that's a really interesting question. I think we could probably talk about this one for an hour on its own. The law is meant to support the gestational carrier's right to make all health and welfare decisions for herself and for her pregnancy. The law, I do not think, was intended to allow a surrogate to simply just say, you know, I don't care about this pregnancy. You know, I'm going to engage with these people. I'm going to take their money and run, and then, you know, terminate the pregnancy. I don't think it was meant to support that. So it's okay, I think, in these contracts to say what the parties agree to, but also state what their intentions are. That, you know, her intention is to carry the baby, let them make medical decisions as long as her health and welfare are protected. And they do this, you know, collaboratively. This is not just a one-sided affair. You really, in these arrangements, have to respectfully balance the fact, you have to balance this fact that it's their baby, but her body. She must be allowed to make decisions regarding her body, but she has to respect that it's their baby. So they can come together and make an agreement. The question is whether, you know, if she agrees, for instance, to terminate if the parents request. Let's say there's a defect, a serious defect or abnormality that's discovered in an ultrasound or a test of some kind during the pregnancy. And they've agreed in the contract that if the parents request that she would terminate. If she continues to agree, then no problem. If there's a dispute, then I think she's still going to be allowed to make whatever decision she's comfortable with. It's her body, but she may be in breach of contract. So that's where the last question comes in, as to whether that would still be a breach of contract under the CPSA. Mm-hmm. So I don't have a clear answer for you there.
Mm-hmm. And then overarching this whole conversation, we have to always consider the best interest of the child analysis. So that would always come into play.
Yeah.
Okay, one other question. Are you recommending that intended parents in New York with embryos stored in New York proceed with a GC search in other states that are not New York? So you have your embryos in New York.
Or you could wait 4 days and then you can start looking for surrogates in New York. I mean, that's one of the things that we talk to parents about all the time is be patient. I know that intended parents have been through a lot to get to this point. I get it. I've been through it myself. But, you know, in the lifetime of the child, what's another 4 days? What's another month? What's another 3 months? If it takes time to put it all together properly, then take the time. So yeah, I would not say that to answer that question that they need to look elsewhere. Just wait 4 days.
And also the primary thing of primary importance is to find the right GC and the right fit for your family. She may be in New York, she may be in another state. I think that's always been our approach.
Absolutely. Yeah, it's really important to remember that at the core of all of this production, you know, you've got agencies and doctors and lawyers and insurance and contracts and the law and parentage proceedings and court documents. You've got a human process, a deeply, truly emotional human process. And it's important that people be matched appropriately. There's a relationship here. There needs to be trust and respect here in both directions. So finding the right surrogate is really the key to a smooth and successful process. So you should not be limiting yourself to one jurisdiction. You should be looking for the right fit that's good for her and good for you as the parent.
Yeah, that's very true. We're always looking for a mutual matching process. It's not just, is she available? There's so many other factors that go into the selection of a surrogate. So it's a very intensive process, and it shouldn't be based on who's available. There's a lot of considerations.
Yeah.
And geography is one of them.
Geography is one of them. And the other thing too is for parents that have embryos in storage at a clinic in New York, now they don't have to take the risk of transferring those embryos, shipping them to a different clinic, sure. Which can sometimes, you can lose embryos sometimes in that process. I don't know what the statistical chance of losing them are, but it's a risk. So you can eliminate that risk if you are comfortable with your clinic in New York. Stick with the clinic in New York.
Absolutely. Just going back to the preconception care insurance requirement. So that's different to other states, correct? So this is even before she would have to have all her bills covered up to that, before that.
Yeah, the idea, of course, is to make sure that the surrogate's medical bills are covered all throughout this process. It's not common in most other states to have the health insurance in place for this preconception care, because actually most of the care that she's getting at that stage is through the clinic, and the parents are paying for all of those medical expenses directly. Sometimes there can be insurance to cover her for potential complications. There's a separate insurance just for that, but most maternity health insurance won't cover the IVF process. So the part of the cleanup bill is to clarify at what point the insurance really must be in place. So that's a TBD. I think it's going to change just slightly.
There's a lot we could talk about. Is there anything else that we missed, Rich, that you want to cover?
Well, we didn't really talk about embryo disposition agreements or posthumous conception, but those are sort of tangential topics, maybe another day. I think we're pretty good as far as the surrogacy statute's concerned.
And if anybody has any questions, I think we're done. Marnie, anything else to add about your feelings about the CPSA?
Listen, I'm really excited about it. It's going to bring a lot of opportunities for families in New York to continue within their own state, to work with women in their own state to build their families. And I think it's great for women who want to help a family and be compensated. So all these measures that are coming into effect are protective of the rights of your gestational surrogate, and they're also providing peace of mind and direction to families along the way. So I think it's terrific, and ultimately it could serve as a showcase for the rest of the country in a way to protect the rights of the parties in the process, in an area that is not super regulated. So it's interesting. So it'll be interesting also to see how other states respond once this rolls out. I think it's very exciting. And I just also want to comment that someone indicated that I said no agencies are screening any potential GCs. I just haven't seen any across my desk. That doesn't mean that there's no screening going on. People may be starting processes that I'm unaware of, but certainly no one's going to start presenting candidates until the laws are changed, which go into effect next week. So very excited though for the coming.
Yeah, same here. I couldn't have wrapped up any better, Marnie. So, yeah.
And how do people get in touch with you, Rich?
Anybody that would like to reach out to me can email me at rich@iflg.net. I
will put that in the chat, and we'll also have that available afterwards. Thank you so much. We could talk all day, but I think that's it for today. Thanks, Marnie.
All
Thanks,
right,
Rich.
thanks, guys. Have a great one. Bye-bye.
Bye.
Bye.